Thank you, ma'am. Now I request our guest speaker, Dr. Vinita Mohindra Madam, to deliver her lecture. Vinita ma'am.
Okay, thank you, Aarti. Thank you so much. Am I audible?
Yes, ma'am.
Okay. I'm feeling overwhelmed with such a great introduction, Aarti.
Thank you.
Thank you so much. I feel so proud to be here, sharing common platform with Dr. Suman Malik, Dr. Supriya, and especially your chairman, Mr. D.D. Datani, who happens to be an alumnus of Manet. I really feel proud to be here as a speaker. I mean, though I'm not a great big expert on intellectual property rights, but I feel I'll be able to quench the thirst of the researchers, academicians, and students of your institute. Okay, so I'll start sharing my screen with you. Please see. My screen is visible to you?
No, ma'am.
No?
Still not. No.
Yes, yes, it is visible.
It's visible? Okay.
Right.
I'll make it full screen. I guess now it is visible.
No, ma'am.
No,
No,
ma'am.
no, no. Presentation is not visible.
Not still on the screen.
Suman ma'am, few of them are telling that it is visible.
Ma'am, you
You
are
are visible, but your
Okay,
presentation is not.
Presentation is not.
Is it visible now?
No, no.
No. Oh.
Ma'am, now the screen is visible.
Okay. I'll make it full screen.
Yeah.
I guess it is full screen now.
Yes, yes.
Yes.
Okay, fine. So now I'll begin my presentation. Um, this is my PPT. I'm showing this screen to you. Please go through this thoroughly, because once I'll complete my presentation, I'm again going to come back to the screen. Okay, so please see to this picture. Next. First of all, I should give you a background, or I should tell you something about concept of property, because all of us have different concepts. For a person who is a layman, concept of property is different. For a young boy or a girl, they feel when they own an expensive mobile or something gifted to them by their parents as their dearest property. For academicians like us, property means different. So let us see that property that is available to us can be either tangible or intangible. when I'm talking of tangible, it means something that can be measured, something that you can actually see, you can realize. But intangible properties, something which cannot be measured, you cannot touch it, but you possess it. So the examples of tangible properties can be movable or immovable in the form of a vehicle, a building that you own. Intangible property, which is unmeasurable, is intellectual property. It is the creation of human mind, human intellect, which is further divided into industrial property and copyrights. Sometimes people confused between patent and copyright. Okay, so they do not understand the basic difference between the two. So when we are talking of industrial property, it constitutes of very importantly patents, designs, trademarks, geographical indications, trade secrets, and even traditional knowledge. Then the other form is copyrights.
Dear friends, please listen me carefully.
Now, intellectual property means creative ideas and its expression. Now, these creative ideas originate in human mind. It originates because of intellect that human beings possess. But they have to have some commercial value. Unless and until they do not have commercial value, we cannot categorize them as intellectual property. Okay. Now, it is an asset, just like any other form of property, which is tangible. Intellectual property is also an asset, which can be bought, which can be sold, which can be mortgaged in the banks so that we can take loans against them. You can license them, you can exchange them, you can even deposit them in the bank and earn royalties on it. So intellectual property is a vast source of earning profits, becoming wealthy and prosperous for any human being. It's so not, and all of us possess this property. Very nice, good thing, but we do not realize what we are doing with this. I will now here enumerate certain benefits of intellectual property. It avoids duplication of research. Now, what happens when we realize our intellectual property in the form of registration? When we own it, we are getting a monopoly right over it for certain period, because the monopoly period of different intellectual properties are different, but the owner gets monopoly over it. Therefore, they debar others to make use of it without your consent, without the consent of the creator of that property. Therefore, it avoids duplication of research. And researchers, academicians, students can utilize the published patent specifications to carry out their own research activities. They can use it as a stepping stone. The person who has received, who has been granted patent or ownership over their property, intellectual property, now information, that documentation can further be used for coming up researchers to carry out their research activities in that particular field. Because what happens, say for example, I'll talk about patent. Patent is granted for a period of 20 years from the date of filing. So once this 20 years ceases, that information now can be used by anyone. That becomes a public property and information comes into the public domain. And this information can be used by researchers to carry out the research activities further. Since this is the most authentic information available to us in the form of patent document, it is the state of the art information that is available. So you are kept informed about the latest development in the field of science and technology. You make profits out of it. You earn royalties on your creations. So that is, you have exclusive right, you have monopoly right over your creations, over your inventions. Secondly, this is also an indicator of achievement for an individual or for an organization or for an institution. Nowadays, when we write our biodata, earlier we used to say I have published these many number of papers in journals. Then what type of journals? Now they ask how many patents have been registered, how many patents have been granted, how many technology transfers have been done by an organization or an individual. You will be surprised to know that you even save taxes on your intellectual property, because government is coming up with number of schemes, especially for the women scientists, where now all this property, when we file, you have to pay certain amount of registration fee from time to time. So for women entrepreneurs or women scientists, government has waived off the fees. Recently it has been added in the Gazette of India. You can even get bank loans by depositing your IPR into bank. So these are the enormous benefits that you can gain with your intellectual property. You can sell it, you can manufacture your property, you can earn profits by way of licensing it to the manufacturer, or you can earn copyrights, you can earn royalties on your copyrights. Okay, so it is. Now, this is rather a big question in front of us, that you have an innovation. How do I protect it in the market? Is it by way of copyright, design, patent, trademark, or geographical indication? So this is a question. I'm sure you will get the answers once we finish off today's presentation. Just go through this slide. This is types of various IPRs, including patent, trademark, copyright, geographical indication, industrial design, and trade secret. Now, first of all, I'll be talking about copyrights. Copyrights is denoted by symbol C inside a circle. I'm sure all of you are aware of this, that copyright is denoted by symbol C inside a circle. Now, the Indian Copyright Act 1958 governs the system of copyrights in India. We are governed by Indian Copyright Act 1958, which was amended in 1983, 84, 1992, 94, 99, and 2012. And the latest amendment of 2012 contains substantial information by which we are governed as far as Copyrights Act is concerned. Now, the meaning of copyright is that it is a right which grants protection to the unique expression of ideas. It grants protection to the unique expression of ideas. The term original means in copyright that the work has originated with the author. When we say that copyright is given to the original and unique expression of idea, it means that the originality lies with the author, the creator. So The important point to note is that copyright protects the expression of an idea and not the idea itself. How that particular idea is executed is being protected by copyright law, not only the idea. Ideas are not protected. Remember, expression of ideas are protected. How uniquely, how originally that idea has been expressed. Of course, there is no requirement for novelty or uniqueness because these are essential features of patent. These are essential features related to industrial property. Now, all literary works, cinematographic films, dramatic works, musical work, artistic work, and sound recordings are covered under copyright. All literary works, cinematographic films, dramatic works, musical work, artistic work, and sound recordings are covered under copyright. Now, what is not covered? Ideas are not covered, but expression of idea can be copyrighted. Facts are not covered because when something is a fact, it is not original. It is known to everyone. So facts cannot be covered. Recipes again are not covered because recipes are patented. You can patent your recipes, which are novel and unique. Works lacking originality, like phone book, maybe dictionary. So all of it's known. It is known. So these are the works which lack in originality, cannot be copyrighted. Names, titles, and short phrases are also not copyrighted, but they can be protected under trademarks. Names, titles, and short phrases can be protected under trademarks. Next, scope of copyright. Any original work which is literary, dramatic, musical, and artistic in nature. Work ideas expressed in material form, but no copyright in ideas or facts. Then cinematographic films and sound recording. Now, important is who is the owner of copyright? Who is the owner? Suppose it is a literary work, then the author who is responsible for creating that work may be a drama or music or novel, any article, poetry is the owner of that particular work. In case of literary work, author is the owner. In case of drama, dramatist is the owner. Music, composer is the owner. In case of artistic work, like painting, the painter, sculpting, sculpture, works of architecture, architect who has created that work is the owner. In case of photograph, the photographer who has clicked the photograph is the owner who can copyright it. But if you are working with some organization, if you are working with, say, you are working with some newspaper publishing house who is publishing newspapers every day, and you are a photographer employed with that publishing house, and you are clicking pictures on the behalf of on the pretext of covering some news for the newspaper, right? So in that case, since you are being employed, you are an employer of that publishing house and you are being paid for it. So in that case, your employer, that is the publishing house, is going to own that picture, that photograph, not you. This is the difference. In case of computer program, person who causes, who creates that work is the author. When we talk of computer program, you can call it a software which is based on algorithms. So in India, it is copyrighted. Softwares in India are copyrighted, whereas in other countries like Europe or America, softwares can even be patented. But we have different laws and laws are different in different countries. In India, a computer program is copyrightable. In case of cinematographic film, producer is the owner, sound recording, producer is the owner. In the course of employment, employer is the owner. Employment by newspaper, magazine, this I have already covered. Employer has publishing right, other rights are lies with the author. In case of photograph, painting, cinema, for valuable consideration, person who pays money. Suppose you have written a book and you come into contract with the publisher that every piece, a single piece of book that is going to be sold, you will get certain amount of money, right? So it is according as per the contract that you are entering with the publisher. Either you may take a lump sum amount of from them, or you will charge something on every book that is being sold in the market. Lecture delivered in public, owner is going to be the person who is delivering. In case of government is this. If I am a government servant and I am doing something at Manage, I am creating something and I am registering, the first party is going to be my institute, Manage, and government has all the right to use it, because first of all, I am employed by them, and secondly, I am using the infrastructure of that particular institute. In case of public undertaking, work of international organization, encyclopedia, dictionary, editor for collection, music under contract by film producer, owner. Now, duration of copyright. So all literary, dramatic, musical and artistic works published during the lifetime of author, here pay attention to the lifetime of author, is life of the author plus 60 years. So you can see that copyright protection is for a longer period of time. It is a very long period of time, life of the author plus 60 years. But in case of other works, it is 60 years from the date of publication. Other works means if the work is posthumous, that is the author of the work has died, it means posthumous. Or the work is anonymous, which means that the name of the author is not known, but someone on behalf of that author publishes. So it is 60 years from the date of publication. All works of government, 60 years and 60 years. Cinema, sound recording, photograph, all are protected for a period of 60 years. Here important is that duration of protection of copyright is very long. So you are the original creator of the work is like relaxed. Now anyone who is going to use this work can be sued in the court of law. And most of the time, most of the cases that happens in copyrights are in film industries. The recent case you might have heard of, a famous movie Padmavat. There was a lot of hue and cry by the public when this movie was made. Okay, so you have to be very careful. Once you have copyrighted your creation, you have to be very careful that no one misuses it, or when they use it, they take permission from you. The advantage is that it is protected for a long time. Limited protection is enough with some industries and technology, and it can be used as an asset. Next, I'll come to trademarks. Now, trademark is a symbol, logo, word, sound, color, design, or the device that is used to identify a business or a product in commerce. Okay. Trademark can be a symbol, logo, word, sound, color, Now, symbol, I think you understand. It can be a symbol. Logo, we are all aware. Even words. In the next slide, I'll be showing you the various pictures of trademarks. Sound. You can imagine that sound is also can also be trademark, a particular sound. If you have seen movies of James Bond, whenever there is whenever James Bond enters, takes an entry, there is a peculiar music that is being played, and that is protected. Okay. The different symbols that denotes trademarks are TM, SM, and R inside a circle. TM means when you have filed your application to protect your trademark for products. SM means when you have filed your application for the protection of services, for trademarks for services, because there are two types of trademarks: trademarks for products, for goods, and trademarks for services. So TM is when you have filed. TM and SM, you use TM and SM till it has not been registered. Once the registrar office gives you a certificate that your trademark has been registered, then you start denoting it by using your, if it is a symbol, and R near it, R inside a circle. Okay. Now, trademark is covered under the Trademarks Act 1999. It came into effect in 2013. The term of protection of trademark is 10 years, and it can be perpetually renewed for another 10 years. You can continuously renew it for 10 years, 10 years, 10 years, till the time it is actually being used by the in business. Once you stop that particular business, it is not going to be renewed again and again. These are the popular trademarks. I'm sure all of you are aware of it. You might have seen Coca-Cola. The color red is also protected. The way it is written. McDonald's, here the the letter M, as well as the slogan, "I'm loving it," has been protected. Yahoo, Ford, Big Bazaar, everything, Leopard, Apple.
हाँ 6th C 5th ਪੀਰੀਅਡ ਤੁਸੀਂ ਅੱਧਾ ਹੀ ਲਿਖਿਆ ਹੋਇਆ ਉਹਦੇ ਟਾਈਮ ਤੇ ਬਿਲਕੁਲ ਮੇਰੇ ਕੋਲ ਤਾਂ ਕੁਝ ਹੋਰ ਲਿਖਿਆ ਹੋਇਆ ਮੇਰੇ ਕੋਲ ਲਿਖਿਆ ਦਿਖਾਓ ਕਿੱਥੋਂ ਲਿਖਿਆ ਸੀਗਾ ਉੱਥੇ 6th ਸੀ 4 ਤੋਂ 6 ਵੀ ਲਿਖਿਆ ਹੋਇਆ ਸੀਗਾ ਉਹ ਨਹੀਂ ਲਿਖਿਆ ਹੋਇਆ ਤੁਸੀਂ ਉਹ ਮੈਂ ਕਰ ਦਿੰਦੀ ਹਾਂ ਹੁਣ ਤੁਸੀਂ 6th C ਦੇ ਵਿੱਚ ਪਹਿਲੇ ਦਿਨ ਜੀਕੇ ਦਾ ਪੀਰੀਅਡ ਹੈ दूसरे दिन 8th C पीरियड है ਤੇ 6th C ਚ ਕੰਪਿਊਟਰ ਦਾ ਪੀਰੀਅਡ ਦਿੱਤਾ ਸੀਗਾ 3 4 6 and 7th A ਦਾ 5 ਫਿਰ ਤਾਂ ਡੇਲੀ ਪੀਰੀਅਡ ਨਹੀਂ ਹੋ ਜਾਂਦਾ ਕੋਈ ਦਿਨ ਇਹ ਜਾਂ ਤਾਂ ਨਹੀਂ ਹੈ ਵੀ ਕੋਈ ਪੀਰੀਅਡ ਨਾਪ ਨਹੀਂ ਮਿਲਦਾ ਹੋਵੇ ਮਿਲ ਜਾਂਦਾ ਹੈ ਨਾ ਆ ਦੇਖੋ ਇਹ ਤੁਹਾਡੇ ਟਾਈਮ ਟੇਬਲ ਲਿਖਿਆ ਨਹੀਂ ਹੋਇਆ ਸੀਗਾ ਆ ਪਹਿਲਾਂ ਹੀ ਦਿੱਤੇ ਹੋਏ ਸੀ ਪਰ ਲਿਖਿਆ ਨਹੀਂ ਹੋਇਆ ਸੀ ਇੱਥੇ ਜੀਕੇ ਦਿੱਤਾ ਸੀ ਹੁਣ ਮੈਂ ਜੀਕੇ ਕੱਟਤਾ ਇੱਕ ਪੀਰੀਅਡ ਹੀ ਹੈ ਜੀਕੇ ਦਾ ਤਾਂ ਤੁਸੀਂ 3 4 6 ਦਾ ਕੰਪਿਊਟਰ ਲਗਾਉਣਾ ਇਹਨਾਂ ਦਾ ਤੇ 7 ਤੇ ਵੀ ਜੀਕੇ ਦਾ
उसमें आपको अच्छा है ठीक ही है, मिशन पे डिपेंड करेगा, बहुत सारी चीज पे डिपेंड करता है।
कनेक्शन नहीं है, लूज हो गया, खत्म हो गया, क्या हुआ? कुछ गड़बड़ हो गई?
मैम आप किस मैम नीता मैम की स्क्रीन शेयर नहीं हो पा रही है।
बस मैं भी कर रही हूँ। किसी ने मुझे रिमूव किया क्या, ऐसा मुझे लगा?
नो मैम,
नहीं, ओके
ना 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 जी मैम, अब आ रही है फंक्शन ऑफ ट्रेडमार्क्स, आ रहा है,
ठीक है।
ओके मैम, जी मैम,
मैं इसे फुल स्क्रीन कर रही हूँ।
जी मैम।
Dear friends,
Well,
please
ये
listen
हट
me
सकता है।
carefully.
Okay, I'm extremely sorry. I don't know how I lost the connection. Okay, I guess I'm visible, Supriya. I'm audible, Supriya.
Yes ma'am, yes.
Okay.
And screen is also
Visible.
on the screen also.
Okay. So
Yeah.
now functions of trademark. No, I was talking about that there are 45 class of trademarks, 1 to 45, and 1 to 34 are classification of goods. Like, and from 35 to 45, it is classification of services, trademarks registered for services. So the classification of good can be chemicals, paints, pharmaceuticals, jewelry, lubricants, furniture, and so on. And services are like aviation industry, hospitality industry, hotels, medical industries, real estate, and so on. So there are 45 classes of trademarks, because when we talk why one should go for trademark, so it identifies